Um, Welcome back to our Land Law and Conveyancing lectures. Last Monday, we are looking at some kind of cases dealing with men and women, either which are not married or sometimes even they're married. But before, in the old days, it's usually it was usually the man who would register as the legal owner of the property, and when the man and wife, or man and woman fell out, then there was a dispute in relation to the ownership of the property, particularly the so-called matrimonial home that they are occupying. And according to common law, well, you only look at the format. Whoever registers as the owner is the owner. So when you go to equity, you have to show that you have made contribution, direct contribution to the purchase price in order to acquire the beneficial interest or equitable interest. So no matter how much you have contributed to the family itself, give up your job, take care of the children, pay the school fees, buy all the furniture, pay all the utility bills, all these could not be recognized by the court as means to acquire equitable interest of the property. You can only get equitable interest by either directly contributing to the purchase price, or if the property is under mortgage, you pay the mortgage installment to the bank. So ultimately, in this case, Grant and Edwards, the Court of Appeal, English Court of Appeal, said that, well, if the court can find a common intention between the man and woman, that the property should be property for both of them. If that is the case, then the court would not just look at direct financial contribution to the acquisition of that property that is paying the purchase price or mortgage installment, but there must be cogent evidence to prove that the common intention exists. And in this particular case, the common intention is supported by the fact that, when the wife or when the woman and the man purchased the property, the woman was actually divorcing her husband, and there was evidence, accepted by the court that the man, in fact, persuaded the woman not to put her name in the conveyance, in that transfer of property, by saying that if she did that, she would get less, in that matrimonial proceeding, because, in the old days, nowadays everything is rather straightforward. Unless there is any special circumstances exist, then the prima facie approach of the court would be 50-50. Okay? No matter the wife or the husband did not work at all and make no direct contribution to the finance or fortune, accumulated in that family. Or in the past, there was other rules apply. For example, if, only the husband worked, the wife only stayed at home as a housewife, so she did not make any direct contribution to the fortune accumulated in the family, then in the old days, the court could at the most give 30% of the family property to that woman. But in I can't remember exactly the year now, 1992 or 1, there was a landmark case decided in England House of Law. And from that case onward, now the formula would be 50-50. And no matter whether one particular spouse has not worked at all or have not earned any income to the family, unless there are special circumstances exist. For example, I don't know whether you are aware of it or not. Now, in America, it was rather common. There is some kind of what we call the prenuptial agreement. That is to say that men and women enter into a contract saying that, after I get married, for example, the wife or the woman is very, very rich and the man was a nobody, then the man may sign a contract saying that, well, if we divorce, then I would at the most got, say, certain $1 million US, for example. Just for example, I can't say, of course, the real situation, or vice versa. Man is famous Hollywood star, and then the woman was just some nobody, and then when they get married, they would enter into this prenuptial agreement. Well, in fact, in the past, the English court did not recognize the prenuptial agreement. But since about 2000, I would say, I can't remember now, 4 or 5, 2004, 2005 or so, the English court also recognized such kind of prenuptial agreement, as long as the evidence is that both parties, enter into the agreement without any vitiating factors. You remember what are vitiating factors in a contract? Misrepresentation, coercion, etc. Now, so in fact, the law about marriage and well, in case divorce, how the family fortune being distributed between the husband and wife has changed dramatically. And in fact, nowadays we have ordinance to protect the interests of the spouse. But this was, 1986. It was still before the more advancement in the matrimonial law. So, but in this case, it was landmark because this is the first time the court, exercising the equity jurisdiction to allow someone to acquire equitable interest, not by contributing to the purchase price, but by a common intention between the registered owner and another party. And this common intention must be the person whose name does not appear in any conveyancing documents, assignment, etc., or register as the owner, actually should have a share of the property. So later on, after this Grant and Edward case, the advice given to the weaker party, remember, nowadays it could be the man, is to collect as much evidence as possible. And in fact, this is, well, again, I hate to say this to you, or to my clients. I say, well, love is blind. Okay, you remember this phrase. When you are deeply in love with your spouse, you would not care about, who paid what kind of expenses. Or particularly if, say, for example, in many examples, I come across the woman, beautiful woman, married to a rich guy. She got a membership, Hong Kong club, etc. And she wants to have, the first next so-called bloody birthday in for her daily breakfast. It's all right. Well, problem is when the time comes, the man set his eye on another lady. Then divorce comes. And there was a landmark case. I don't want to mention the Persian by name, even though you can find that in law report. The woman asked for a sum of money upon divorce. And she said, well, I have this kind of living since I married with this guy. But then she was being cross-examined by a very famous female barrister. I don't want to mention the name again. Do you know how much a catty of first next cost you? No. Just no idea whatsoever the kind of LV or, LV is really inferior. I shouldn't mention LV at all. AMA, Perkin bag. I don't know if you know about those kind of accessory or not. But anyway, she could not tell. And at the end of the day, she got a sum which is much, much inferior to what she expected. Compared with another case where the woman is so clever to keep each and every receipt and then produce all the receipts in the court and say, wow, this is the kind of living I'm enjoying while I was married to this guy. And with this evidence, she can persuade the court that, a bigger sum of money should be given to her. Because this guy has a lot of money, if he was a wife, you have to pay a price, you let her to lead the same level of living. And in fact, in the Hong Kong case, this approach was followed. The court looked at the fact to see whether it is possible to establish a common intention between the man and the woman that the property, even though only registered in the man's name, part of it should belong to the woman. So the most important thing is whether or not a common intention can be inferred from the action or contribution to the weaker party. And when a common intention is established, and if there's a change of position of the weaker party, or he or she acted to his or her detriment, that is to say, because of this common intention, the weaker party give up something, upon marriage, for example, or living together. A constructive trust may be found by the court. The court may construct a trust in that situation. The registered owner is holding that property on trust for both himself and the woman. Now, there is further development of that, because a constructive trust will give a beneficial interest to the beneficiary. But there are some other cases in which it is not really possible to infer that kind of common intention. But it is obvious that the man has, I say the man, I'm not being biased. In the case law, it is always the man. Give some promise to the woman. Now you can live it forever, or until you want to go, or until you die. Now, if you have this kind of representation or promise, obviously you cannot say that this man intended to give a share of the beneficial interest of this property to the lady. But he just give her a right to stay in the premises until certain time in future. And a very common scenario would be, oh, don't worry, live with me. Well, I have a wife. Well, I don't love her anymore. Well, oh, you have a baby. Now, okay, I'm going to divorce her, but don't worry. Just stay in this flat as long as you take care of our baby. Something like that. Now, this kind of representation would not win, would not make the weaker party earn the equitable interest, because it's clear, no common intention that the party would have a share of the property. And if, on the other hand, said, well, don't worry, I will give you this property, then it will be different, right? So the court developed another concept called proprietary estoppel. We have learned estoppel in our contract law, that is promissory estoppel. It deals with contract where a party to a contract has not made any contribution, I mean consideration. This party can still enforce a contract. It is similar kind of concept. When party give the other party certain proprietary rights, even though that promise could not be enforceable, the party would be estopped from denying that promise. And that is the proprietary estoppel. But there is requirement on the part of the weaker party. The weaker party must have act on or relying on the promise or representation and do something to her detriment. Then the court may find proprietary estoppel. And what is the difference between these two, constructive trust and proprietary estoppel? Now, if the court declares a constructive trust in favor of one party, that party will be definitely entitled to a beneficial interest in the property, because the concept of trust is trustee holding the equitable interest for the beneficial owners. A proprietary estoppel does not necessarily give rise to any proprietary right. Now, it can give a proprietary right, but sometimes it may not. Persian successfully established the proprietary estoppel may only get an irrevocable license. License is permission to stay in the property for life. For example, if the man said, well, trust me, you can live here as long as you like. Now, if that is the promise, then the weaker party may get an irrevocable license. Now, under normal circumstances, license are revocable, but when you have proprietary estoppel, it would estop the person to revoke that license, or for a certain period of time. But now, license is basically a personal property, show in action. But if it is come from a proprietary estoppel, that license may be enforceable against assignee of the legal owner of the property. So, say for example, after the court said that, oh, the lady has established proprietary estoppel, and she can stay in this flat, for example, as long as she is raising up the children. In fact, later on you'll see a case exactly like that. Now, then if the man sold the property to a third party, then in theory it would be defeat the license, because that license could not be enforced against the third party who is not party to the contract. There's no privity of contract. But when this license comes from the proprietary estoppel, this license could be enforced against the assignee of the owner of the property. But of course, say for example, if the licensee only got a right to stay in the property for life, when the licensee dies or when the time expire, when the children become adult, for example, the legal owner takes the property in its entirety. He does not lose any equitable interest in the property, but just being adopted from denying his promise. And this area evolving around the resulting trust, constructive trust, and proprietary estoppel is complicated. And in the exam, if there is any question asked on that, it would only be a very superficial kind of question. So don't have to worry too much. But if you continue to study the LLB level, then this area is something that you have to get yourself familiarized with. Now, as I said, because of the development of the law, and sometimes the court, particularly the House of Lords in England, said that, well, as court, we could not invent new law. Well, we find it unfair, etc., etc. But that would be Parliament's duty to change the law. So as a result, in fact, in the 1990s, new laws to protect interests of spouses were enacted in England and also being copied in Hong Kong. Now, this law only protects the interests of spouses in relation to matrimonial homes, but the protection is not extended to cohabitants. So it's important to register as a couple. Now, Section 9, Marriage Persian Status Ordinance. A husband or wife who makes substantial contribution in money or money's worth to the improvement of real property in which either or both has an interest will be treated as having a share or an enlarged share in that beneficial interest. Now, this is not a contribution to the acquisition of the property, that is not paying the purchase price or mortgage installment, but just to improve the property. That is now counted as a way for you to acquire an enlarged share in the beneficial interest. If you are a spouse, and you can rely on Section 9 of this Married Persian Status Ordinance. But if the couple are cohabitants, then no matter how the man or woman make any substantial contribution in money or money worth to improve the real property, they could not take advantage of this section. And Matrimonial Property and Proceedings Ordinance give the court a wide discretion in the distribution of a spouse property in a divorce action, and that would not be bound by the concept that a party must make direct financial contribution to the acquisition of the property in order to earn the equitable interest. So, in terms of protection to the spouse or to the member of the couple, it's worth to get married, officially married, than just living together. If you choose not to live together, then you have to take care of your own interest by the landlord instead of the matrimonial laws. Okay, so that is about the co-ownership of man and woman, either married or cohabiting. Now, the other form of co-ownership in Hong Kong is the co-ownership in a multi-story building. Now, look at this question. A purchases flat 1A of a multi-story building. Before the purchase, there was a piece of concrete loosened out and fell from the roof of the building. The concrete landed on B's head and seriously injured B, who happened to pass by. B is now threatening to sue owners of the building for compensation. A believes that B's injury has nothing to do with him because he is the owner of flat 1A only. Question asks you to advise A. Is A correct in believing that he would not be liable whatsoever to B's injury? Okay, we'll come back to this question after we learn concept. Now, most common form of co-ownership in Hong Kong is the co-ownership in respect of a multi-story building. In fact, this area of law is unique in Hong Kong. In fact, if you still remember the concept of common hold, and the Common Hold Act was enacted in 2004, and England, in fact, copied Hong Kong in that respect. Now, in a multi-story building, all owners are not individual owners of their individual flat. They are co-owners, holding their interests as tenants in common in that multi-story building. And they co-own because they are tenants in common, unity of possessions, remember? So they co-own all parts of the building together. Then how can someone claim himself to be the owner of flat 1A? Of course, that is legally incorrect. But the reason or legal basis that certain Persian can have exclusive possession of certain flats in a multi-story building does not come from their proprietary rights, but come from a contract, even though the contract was executed in the form of a deed. The deed of mutual covenant. Covenant just means, agreement or so. When you purchase a flat, which is, as I said, legally incorrect to say so. Now, what you get in relation to the interest of that piece of land on which the multi-story building is erected is certain undivided shares of the land. The concept of co-ownership held under tenancy in common, and in most cases we'll describe that as equal undivided share, because each share equal to another share. But how many equal undivided share will be allocated to a building will be decided by the developer of that particular building, or if the housing estate, it would be the developer of the housing estate. So each multi-story building would be assigned or allocated a number of shares, equal undivided shares. Or say, for example, you have a big piece of land, there are 10 buildings erected on that 10 piece of land, then the developer will then think of a number as the overall number of shares for this piece of land. And each of the buildings will be allocated a certain number of shares. And each of the so-called owner, under quotation mark, purchasing a flat in one single building will also be allocated a number of equal undivided shares, so that he becomes one of the tenants in common of that piece of land. Now, how they get the exclusive possession of certain units, and that is the deed of mutual covenant. This is a contract. Remember, a contract by deed. There is one good advantage: you don't have to show any consideration in order to enforce that contract. But anyway, under this deed of mutual covenant, each so-called owner holding certain number of equal undivided shares will have the exclusive right to occupy certain units. Say, for example, flat 1A, maybe that owner will be allocated, say, 15 equal undivided shares of the land, together with the exclusive possession of flat 1A. Now, so the share is proprietary right. The right to occupy flat 1A exclusively is contractual. It is only the owners agree with each other that this guy will have the exclusive possession of flat 1A, another guy would have the exclusive possession of flat 1B, 2A, 2B, etc., etc. And this number of shares usually would be corresponding to the size of the flat. The bigger the size, the more number of shares you will be allocated. Now, if there are car parks, now in the old days, the car parks would not be allocated with equal undivided share. That would also be, allocated to individual owner under the deed of mutual covenant. So this person who got 15 units of equal undivided share would have the right to exclusively occupy flat 1A as well as car park number 8, for example. So don't tell, after you study land law, don't tell anyone, I am the owner of flat 1A. You can only say, I am one of the co-owner of this multi-story building, and I got a contractual right to exclusively possess flat 1A. That is the correct description. Remember the first slide that I showed you? What does it mean when I say I own a flat in Thai Crusade? Then you have to see how the DMC, the Deed of Mutual Covenant of Type 2C, to see how many number of equal and divided share you were being allocated, and your right to occupy which particular unit of which particular block. That is the meaning of I am the owner of flat 1A of certain building. So, as I said, owner of flat 1A does not in law own this flat 1A. He only has certain equal undivided share of the land on which the building is erected, and the exclusive possession of flat 1A by virtue of the deed of mutual covenant. So it is a contractual right only. And this equal undivided share, coupled with the rights to exclusively possess a certain part of the building, is transferable to anyone and binding the successor of other tenants in common, because all the tenants in common enter into this deed of mutual covenant, which is one kind of land covenant, which we will discuss that later on. And as land covenant, they can overcome the restriction of privity of contract, so that no matter how many times the original owner of that number of equal and divided share has transferred to their successor in title, their successor in title, by virtue of the equal and divided shares they acquire from his previous predecessor in title, they can enforce the DMC against all the members within the DMC. In that case, he or she can retain this contractual rights to exclusively possess flat 1A. Of course, together with the number of equal and divided share. Now, as I said, in the past, you will not get any share for occupying a car park space. And in fact, that has been horrible. Hong Kong people are so crazy about real property. If I cannot afford a flat, I will purchase a car park space. Now, you must be careful if you just want to purchase a car park space. Make sure that under the DMC of that building, the car park space is being allocated with a number of with some number of equal and divided share. Usually, the car park space would attract only one unit. Now, this one unit is very, very important, because when you acquire this one unit of equal and divided share, you become one of the co-owner, and then you can enforce the DMC. Within the DMC, certain person getting this this single number of equal and divided share would have the exclusive possession of car park space number 8, for example. Then no one can park their car in this car park. Now, in the old days, when car park space is not being allocated with equal and divided share, everything remained to be contractual. Now, if you purchase the car park space with the so-called owner, yes, you can enforce this contract against this guy, and this guy can then enforce the DMC against other owners, so that no one can occupy car park space 8. But what if this guy sells the property to a third party? That's another story, because the contract between you and that guy cannot be enforced against the third party, the new owner. Then the new owner can say, the rights to exclusively possess car park number 8 is attached to the number of equal and divided share given to me. So I am going to get back the car park. Well, in fact, there has been litigation in the past in relation to that, and the court said, well, that is the case, because you do not have number equal and undivided share. You are not member, or you are not one of the co-owners. You have no right to enforce the DMC against members of the DMC. And therefore, in fact, the more recent development, I think after 1980s, most of the building, when they have car park, there would be at least one unit of equal and divided share assigned to the car park. Now, if you are owner of a flat and have a car park, you can look at your own assignment or look at your DMC. You can see how many number of equal and divided share you have in relation to the flat, and how many number of equal and divided share you have in relation to the car park that you are occupying. All such share will be clearly spelled out in the DMC. Now, what are the use of those equal undivided share? Now, when the building as a whole is sold, then how the money could be divided among the existing co-owners? That would be in accordance with the number of equal and divided shares they have. And what if they need to renovate the building? Who is going to pay for that? Again, the total cost would be collected from the owners of those equal and divided shares in accordance with the number of equal and divided shares they have. So you have, if your unit is larger, then usually you have to pay more. Now, because of this concept of holding this number of equal and divided share to acquire your co-ownership, tenants in common, in a multi-story building, we have some kind of development in certain particularly commercial premises. Now, all begins with this case, Shinip Industry Limited. Well, in that case, the Deputy Judge Maria Yun, she is now in the Court of Appeal, held that a developer of a site was free to allocate the shares he then had in whatever manner he thought appropriate, unless there was clear wordings or necessary indication to indicate that there were any constraint upon his rights. In other words, if you are the developer, you hold the entire interest of the land before selling out the units of the multi-story building. You can decide, well, in fact, by the way, later on you'll learn about that, who would be the party to execute the DMC. Even though all the so-called owners are members, the DMC is not required to be executed by all owners. There are only 3 parties to sign or execute the DMC: developer, the manager, and the first purchaser. You can expect the first purchaser is almost always, well, in fact, I can say always, just in case there is really some exception, some associate of the developer. So how to draft this DMC is entirely within the power of the developer. So he can, in fact, insert some very harsh provision in the DMC against the co-owners and in favor of himself. And in fact, in the past, we did see that kind of DMC. And that's why later on, government has to enact an ordinance now known as Building Management Ordinance to regulate the DMCs in Hong Kong. Okay? So the developer, because he is the one to draw up the DMC, he can decide, well, even though I am the owner of one car park, one unit, I can have a big, more number of equal and divided share than the other owners in relation to the car park. Well, because he has full freedom, free hand to do that. And this case was then later on followed by another judge, Justice Wu, who held that in order to restrict the rights of allocation of the undivided share, there must be clear and certain wordings to that effect. So in other words, there is no restriction in most cases for the developer to allocate the shares. Now, they are not that important for us, but the case here, Next Universal Design Consultants Company, in which Madam Justice Bichon, she retired from the Court of Appeal already. And she said she developed the ratio in Shinip as a matter of principle. There was no valid basis for differentiating between the position of the developer and that of a subsequent owner in the right of allocating the undivided share to whom they belong. In other words, now there is no restriction for any owners of that piece of land to allocate the number of equal and divided share allocated by the developer. So developer has freedom, you purchase flat 1A, I'll give you 15 units. Now, if flat 1A can be further divided, this owner can then divide it up and allocate the 15 units he have to individual portion. And he can also execute a sub-DMC, because it's subject to the original DMC, to regulate the mutual rights and liabilities between the co-ownership arising from the subdivision. I'm talking about the subdivision now. Now, okay, give you an example, because this is important in most cases to commercial building, because, in the past, for domestic premises, you are not allowed to subdivide your flat, for example. X purchased the entire ground floor of a commercial building, a shopping arcade. Well, originally there was only 4 shops in that floor, and according to a DMC, for example, now we have this kind of scenario. Okay, 1, 2, 3, 4. These are the shops. Of course, they are common areas for people to come in and go out. Now, this is the original allocation or design of under the old DMC. Now, if I acquire the entire floor, by virtue of the ratio of that index case, I can block down the wall. Now, as long as I do not violate any building regulation, I can cut those shops into smaller units, and then for example, in this case, both have say 4 units, so altogether 16 units. I can then give half 2, 1, 1, 2, 1, something like that, because I have freedom to allocate any share as an individual owner. And in all now because all these owners, so to speak, have to pay electricity fees, water bills, etc. in relation to this floor, and management fee in respect to this floor, I will execute a sub-DMC to say, oh, if you have 2 units, you have to pay or responsible for how many percentage of the expenses, for example. And nowadays in Hong Kong, if you go to certain shopping center, you have the so-called 格仔鋪, all this come from this concept. Of course, if you really execute a sub-DMC, this sub-DMC would only be relevant to this particular floor, whereas all the owners in this floor is still subject to the original DMC. Now, and in theory, co-owner can having exclusive possession of only one flat, may also subdivide his flat and sell it to 2 different purchasers. Now, the illegal position of flats, Tong Fong, prevailing this day in Hong Kong is made possible by virtue of this concept. It is illegal practice simply because it violates the building regulations. Now, if you conduct you become a landlord lawyer, you will also study the building regulation. You will see that, for example, if you are talking about commercial building, they will estimate how many occupants will be there and how many visitors will be there, and the regulation will then prescribe that, say, for example, how many urinals you must install in a gentleman's toilet. Now, and usually you are not allowed to set up as many toilets as you like. Therefore, the current current practice of Tong Fong, in which people would have their own kitchen and toilet inside that small unit, is obviously in violation of the building regulations. Of course, now the government say they are going to introduce rent control for the Tong Fong. That means, in a way, they are now recognizing that this is legal. So every co-owner is entitled to possession of each part of the land, unity of possession, and in theory, can exert his right on each and every part of a multi-story building. And this will create confusion and difficulty in the management of this building. Now, of course, under the DMC, we can say, oh, this particular owner has exclusive possession of flat 1A, the other would have exclusive possession of flat 1B. No problem. It can be solved by the DMC. But what about the common parts of the building? The staircase, the hallway, the landing of the staircases. their common parts. If being a co-owner, I can occupy those common parts as well, because unity of possession. Now, therefore, the government enact this building management ordinance, not just to regulate the DMC, but also, the management of the building in relation to the common parts of the building. And Section 16 of this ordinance said that on incorporation, the rights, privilege, and duties of the owners, that is all the co-owners in the building, in respect of the common part, shall be exercised and performed by the corporation. This is it refers to the owners incorporation, by the corporation to the exclusion of the owners. So, even though under common law, under this concept of tenancy in common, each co-owner should be able to exercise his right to the common part. By virtue of this statutory provision, the right of the individual owners would be given to the owners incorporation exclusively. So that if the owners corporation set up certain house rule, you cannot put your goods or your belongings on the hallway, then you cannot say, well, I am the co-owner. I can make use of each and every square inches of this building. Therefore, I can put my belonging in the hallway. Now, they would say, oh, yes, that was true in common law, but we can rely on Section 16. And please, either you take those away or we would enforce our right against you. So the liabilities of the common parts shall also be enforced against the incorporation instead of the individual owners. For example, if any Persian suffer injury at the common part, then the individual should not sue individual owners of that building, but sue the owners incorporation. So under this Section 16, a co-owner is prohibited from instigating any proceeding against another co-owner who has occupied some common parts to the exclusion of other co-owners. This has to be done by the owners incorporation. And if someone suffers personal injury in the common parts of a building, the injured person has to sue the owners incorporation instead of individual owners. So, going back to our question. It is wrong for A to think that he has nothing to do with this, with the compensation of B. Assuming that the concrete loosened out, from the roof, belong to the common part of the building. So when B sue the building, they should not sue individual owners. B should sue the incorporated owners. And then if B succeeds in the litigation, compensation has to pay to B. Of course, the incorporated owners will have no money. All money come from the individual owners. The incorporated owners will then collect money from you. And A, being one of the co-owners, has to contribute to the amount of compensation. Now, then what you may ask, what would be the case if in some old building there is no incorporated owners? Then in that case, all the owners would have to be liable, And if there's no incorporated owners, then B should sue all the co-owners within the building, or just one would be enough. Because that person would not solder the only liability himself. He would then bring in all the co-owners to share the compensation, because unity of possession, everybody has the right and liability for the entire building. Okay? So this is about co-ownership. So from now on, you should never tell anyone you own a flat. You say, I own some equal and divided share and has a contractual right to exclusively possess the unit I'm now occupying. Okay? Now we come to the fourth lecture. We are now looking at the so-called legal estate and equitable interest in not just in theory but in practice. Remember, section 2 of CPO defined the legal estate terms of absolute easement and legal charge. So we look at lease first, leasehold. Now, nowadays, we would classify lease as real property. We would say, or at least the common folk will say, a lease is some kind of real property. Just as I said, all land in Hong Kong are held under leasehold. If you purchase a piece of land, you would think that you have some real property. Again, this is wrong in the analysis of law, because lease is a personal property in common law tradition. In the old days, a lease was only a commercial contract between the landlord and the tenant. So the contract, shown in action, could only be enforced by an action in Persian land, and remedies available were damages. That was the very old day. Later on, because the value of land, the tenant was allowed to enforce a lease against the landlord or third party by an action in rem. Particularly when the lease is a long one. I grant you a 10-year lease to use this piece of land as agricultural land. So you may spend a lot of money in the land. But what if 2 years later the landlord sold that piece of land to a third party under PVT of contract? The third party is not bound by the commercial contract, and say kick the tenant out. The tenant would have no remedy. Therefore, because of the value of the land in such cases, the equity then developed to recognize lease, even though a personal property can be enforced in rem. In rem, another word to describe that it can be enforced against the whole world. And the tenant could obtain the repossession of the land, not just damages, and not bound by the doctrine of privity of contract, because the lease is considered to have conferred a proprietary right on the tenant. But according to the legal classification of a lease nowadays, it is still remained as a personal property, even though it actually confers perpetual right to the tenant. So this is just about history. You can forget about the so-called personal property concept for a lease. Just treat it as a perpetual right. That would be good enough. Now, what is a lease then? Terms of year absolute, of course, but there are actually three particular elements to form a lease. And this was the spelled out by Lord Templeman in the case Street and Mumford. Is that now, if you want to establish a lease, you have to look for three elements in that legal estate or equitable interest. There must be a term and a rent. So get a fixed period for the lease, and the tenant has to pay a rent with exclusive possession. Now, when you pay the rent during the term of that lease, the tenant would enjoy exclusive possession of that piece of land. That means during that term, even the landlord cannot enter the piece of land without the permission of the tenant. Tenant has exclusive possession. Now, a few years later, in a Court of Appeal cases, English Court of Appeal cases, the Court of Appeal said that, well, in fact, it is not necessary for the payment of rent for there be a lease. So that if you read these two cases together, as long as someone get a perpetual right to possess a piece of land for a term, and this possession is an exclusive possession of that piece of land, then this guy must got a lease for occupying the land. Of course, in practice, in reality, in most cases, the tenant has to pay rent, but rent itself is not really the sufficient condition for the existence of a lease. Now, a term, fixed term of year absolute, means that there must be a certain beginning and a certain ending when it is created. So the important point is when it is created. When the list is created, the beginning and the end must already be decided. You cannot just say, oh, I grant you a list for 10 years, but let's decide later on when this 10 year will start. Now, if that's the case, there is not a real terms of year absolute, because we must have a certain beginning and a certain ending. Now, in fact, this concept was all along recognized at common law, and that has caused problem to England. In the Second World War, 1945 is the end of the Second World War, and this was a case decided in 1944, when there was a list purportedly said to be for the duration of the war. So they have a definite beginning, or starting from this day and until the end of the war. But when it was created, no one would know the end of the war. Therefore, there is not a term of year absolute. And the court said that this list is void. This list is void. And in fact, during the Second World War, there are many landlords execute this kind of list under quotation mark. Therefore, Parliament enact called the Validation of Wartime Lists 1944, which convert all such lists, which said the list will end at the day the war ends, to convert the lists to a term of 10 years. Now, without this statutory provision, all such lists would be void, because a list must have a term. A term means certain beginning and certain end. Now, in the wartime, maybe the people are not thinking, was not really thinking careful, but that mistake was committed by a local government, the London residuary body. You know, they grant a list to the prudential assurance companies and said, well, of course, there were definite beginning, but the list is to last until the landlord requires the land for road widening purposes. In fact, that was a case in which the local government wants to widen the road, so they keep up a piece of land. But that plant has not yet decided when to carry out. So in order not to waste the land, they grant the list to prudential assurance. But they also want to make sure that when this plant become materialized, they could immediately get back the land. Therefore, they enter into such a list. But of course, without a definite ending for the list, was held to be invalid for uncertainty. Now, when it is uncertain about it, either you can say it is void, or you can say it is only unlicensed. Now, in a leasehold property, the terms of the lease itself is uncertain, if there is such a case. But the leases also provide the maximum duration for a sublease. Sublease is, the tenant lease the land to a subtenant. Now, if you have such a kind of special situation, then the maximum duration for the sublease may save the lease from being rendered invalid. Because the court said, well, at least we can say that is the end of the lease. There was the Hong Kong case in which the court said, the lease could be saved as a result of the existence of this sublease. Now, term itself is rather straightforward. Certain beginning, certain end. The more difficult or elusive concept is really the concept of exclusive possession. Now, in fact, this is the element in which Lord Templeman distinguished a lease from a license. And he said, an occupier of residential accommodation, now, lease and license, could be relevant to residential accommodation at a rent for a term. License can also be created by requiring the licensee to pay a rent and then occupy the land for a term. Therefore, these two are very similar. But how to distinguish them? The court said that now if you pay a rent for a term, then you can either be a lodger or a tenant. And when the occupier is a lodger, if the landlord provides attendance or services which require the landlord or his servants to exercise unrestricted access to and the use of the premises. Now that was the so-called service apartments arrangement in Hong Kong. If you rent those service apartments, each week there will be regular services provided by the landlord in relation to cleaning up the house, provide certain, maybe towels or other services. But because the landlord has to provide those services, they must get unrestricted access. They can just enter the premises without the permission of the occupier. So this is not a lease. A lodger is entitled to live in the premises but cannot call the place his home, his own. No one would say when he stays in the service apartment, that apartment is his home. If, on the other hand, residential accommodations grant for a term at a rent with exclusive possession, in other words, that occupier can occupy the land and out anyone in the world, including the landlord. And the landlord providing neither attendance nor service, the grant is a tenancy. So this element of exclusive possession is the element to distinguish a lease and a tenant. And in fact, in your exam and in the assignment, there is always, I should not say always, frequently there are questions asking on this particular concept. Now, we'll take a 15 minutes break now, and after that I will explain why it is important to distinguish a lease and a license, even though in Hong Kong nowadays, this need to distinguish these two legal concepts